All right, let's dive right in. Today, we're going to unpack the Sale of Goods Act. Now, I want you to think of this as the ultimate rule book for buying and selling pretty much anything. It's absolutely essential, especially when you're dealing with business and trade that crosses borders.
I mean, we've all been there, right? You get that new piece of tech, you take it out of the box, and nothing. It's a brick. Or maybe you order a very specific part for a machine, and something totally different shows up. It's frustrating. But here's the thing. There are actual legal rules designed to protect you in those exact moments. And that's what we're going to explore today.
So here's how we're going to tackle this. First, we'll get the basics down. What exactly is a sale? Then, we'll pull back the curtain on the contract's hidden rules. After that, a really crucial part, ownership, risk, and timing. Then, we'll look at what happens when deals go wrong, and we'll finish up by looking at the key rights for both buyers and sellers. Sound good? Let's get started.
Okay, first things first. In law, words have very specific meanings. So before we can talk about your rights or what to do when something goes wrong, we have to be super clear on what the law actually defines as a sale. It's the foundation for everything else.
So this whole set of rules only applies to one thing, goods. And what are goods? Well, pretty much any kind of property that you can physically move. So a laptop, a car, a shipment of bananas, even crops that are still growing in a field. Those are all considered goods. What's not included? Things you can't move, like a piece of land or a building. Those are covered by completely different laws.
And a contract of sale, it's the agreement itself. But for it to be a real contract of sale, two things absolutely have to happen. One, the seller transfers, or at least agrees to transfer, the ownership of the goods. We're not just talking about handing them over, we mean the legal title. And two, all of that happens in exchange for a price.
Which brings us to price, and this is a key detail. The price has to be money. It has to be in a currency. If you swap your old laptop for a friend's bicycle, that's not a sale under this act. That's a trade, or what lawyers call barter. For these rules to apply, money has to change hands.
Okay, now we're getting to the really cool part. Did you know that every single contract for the sale of goods comes with a set of hidden rules? They're called implied terms, and the law automatically writes them into your deal, whether you talked about them or not. They're there to make sure the deal is fair.
Now, these hidden rules fall into two categories, and the difference between them is massive. You've got conditions and you've got warranties. A condition is the absolute heart of the contract. Think of it like the engine in a car. If the engine is broken, the whole deal is off. You can return the car, end the contract, and get your money back. A warranty, on the other hand, is more like the car's radio. If the radio is broken, it's annoying for sure, but the car still drives. You can't return the car, but you can get money, damages, to fix or replace the radio. See the difference? It's huge.
And just look at this table of the most important implied terms. Notice something? They are almost all conditions. The law says the seller must have the legal right to sell the goods. The goods must match the description you were given. If you told the seller you needed a waterproof jacket for hiking, it must actually be waterproof. And the goods have to be of satisfactory quality. These aren't just suggestions. They are powerful automatic protections built into every single deal for you, the buyer.
All right, let's keep building on this. Knowing the exact moment that ownership, what the law calls property, officially passes from the seller to you is incredibly important. And you might be wondering, why? Why does the exact timing matter so much? Well, it's because of one simple but very powerful rule.
And here it is. Risk follows property. Basically, whoever legally owns the goods is the one who carries the risk if something bad happens to them. So let's imagine you buy a very expensive piece of art. You pay for it, the contract is done, you are the legal owner. But you decide to pick it up tomorrow. If the gallery burns down overnight, that loss is on you, not the seller, because you are the owner. The risk follows the legal ownership, not who is physically holding the item.
So, the big question is, when does ownership pass? Well, for what we call specific goods, that is, a unique item that's been clearly identified, like that specific painting on the gallery wall, ownership passes the second the contract is made, as long as the item is ready to go. So yeah, you could legally own it before you've even paid or taken it home.
But what about things that come from a larger batch, what we call unascertained goods? Imagine you order 100 bags of cement from a warehouse that has 500. You don't own any cement yet. Ownership can't pass to you until your specific 100 bags are physically separated from the big pile and marked as yours. That act of separation is the trigger. Only then do you become the owner, and only then does the risk transfer to you.
Okay, So we've talked about all these rules, but what happens when someone doesn't follow them? This is where remedies come into play. A remedy is just the law's way of making things right. It's the legal safety net for when a deal falls apart. Let's look at it from the buyer's side first.
And this brings us right back to that crucial difference between a condition and a warranty. If a seller breaks a major condition, say they sell you goods that are totally faulty, you, the buyer, have all the power. You can reject the goods, completely cancel the contract, get your money back, and even claim damages. But if it's a smaller issue, a breach of a warranty, you have to keep the goods, but you can still sue for damages to compensate you for the problem.
But of course, this isn't a one-way street. The law protects sellers too. What happens if the buyer is the one who breaks the promises they made in the contract? Let's flip the whole thing around now and look at what rights the seller has.
So for the seller, the main tool is to sue in court. If a buyer just flat out refuses to pay for the goods, the seller can take legal action. And here's where our old friend ownership comes back into play. If ownership has already legally passed to the buyer, the seller can sue for the entire price of the goods. If ownership hasn't passed yet, they sue for damages, which is usually the profit they lost because the deal fell through.
But an unpaid seller also gets some special, very powerful rights. First up is the right of lien. This is simple. It means the seller can legally hold on to the goods, just keep them in their possession until the buyer pays up. And second is the right of stoppage in transit. This one is huge for international trade. If the goods are on a truck or a ship heading to the buyer and the seller finds out the buyer has gone bankrupt, they can legally order the shipping company to stop the delivery and bring the goods back. It's a powerful way to protect themselves.
So there you have it, the fundamental rules about quality, ownership, and risk that form the foundation of almost any sale. But here's the final thought I want to leave you with. These rules work great when everyone's in the same country. But what happens when your buyer's in Germany and your seller's in Japan? How do these rules change when goods and money start crossing international borders? That's the next big question in your journey through international business law.